I am the president of the Palm Beach County Justice Association, and we are very excited to be able to continue our Friday morning webinars with Jay Scarola, our champion of justice, Melissa Scarola, his lovely partner, wife, and the rest of the SAGE Settlement Consulting team. We have in the past few weeks, as we transition to this COVID-19 remote way of practicing, have been focusing our webinars on, the new ways to adopt technology and how to do remote depositions, remote mediations. And those are all very important topics, but we need to make sure that we are also focusing on beefing up our toolbox that helps us all be better lawyers and continue to help us get better results for our clients. The ability to work with settlement consultants to help us reach that settlement for our clients has never been more important. Because there aren't going to be any jury trials for a while, and even when they start back up, there's going to be a backlog, but also because being able to maximize the value of a settlement has never been more important. People are really hurting, and being able to, stretch a dollar out is really crucial right now. So being able to bridge the gap between what the defense is willing to pay and the client's expectations really can be done through some of these tools and some of these options that Jay and his colleagues will be speaking to us about. So I think it's really, really important, and I'm really, really thankful to Jay, Melissa, the rest of the folks at SAGE and their sister companies, as well as Family Network on Disabilities. They're also a great supporter of Palm Beach County Justice Association. So I know that, a lot of the webinars have been just kind of focused on the remote way of practicing, but we can't neglect this part of what we do, because we need to continue to be able to get those cases resolved for our clients. For those who may not know, Jay Scarola is a senior settlement consultant with SAGE Settlement Consulting. He has been with what is now known as SAGE since 2001. He has earned the distinguished designation in settlement consulting from the College of Business at the University of Notre Dame. He has probably more experience in helping catastrophically injured clients than a lot of us here on this call. So we're so thankful for him making time to help us be better lawyers and get better results for our clients. So with that, I will give the floor to Jay, who will then be introducing the rest of his team. Thank you, Jay.
Thank you, Adriana, for that lovely introduction. It certainly makes me look better than I am. I've already gotten a few text messages, so I'm going to go ahead and address it right now. Yes, I do have a killer mustache right now. The mustache, thank you, Tim, is in honor of the COVID-19 pandemic that we're currently enduring. And at first I couldn't figure out how to social distance with my wife, and this seems to have been the only thing that will actually work. So once social distancing is lifted, I will ultimately shave it so that she can sleep next to me in bed again. That being said, as you see on your screen, we have a basket that we will be raffling off at the end of the CLE today. Please email Melissa now. Her email address is up. It'll pop up a couple more times throughout the presentation if you would like to enter to win that. So that being said, today we're going to be talking about how to get cases resolved in the COVID-19 environment and beyond. I think that we can all agree times are drastically changing. The way that we're all doing business is changing. If you would have said Zoom to me a month and a half ago, I would have thought that you wanted to take me for a ride in your new Mazda. And now here we are. Everybody's running their practices, running their respective businesses over Zoom meetings. So I think there's a lot of growing that we all need to do, and that we're all currently doing and adapting. And I have been very impressed at how all of that has been going and how welcoming everybody has been to it. I have never done a Zoom presentation like this, so this is a first for me and a first for a lot of the team who's going to be working with me today. Adriana basically just kind of went over my background. The agenda today, we're going to obviously talk a little bit about structured settlement annuities, which most everybody is fairly familiar with. I will touch very briefly on that. And then from there, Brian Smith, who is the Vice President of Sales and Marketing at Structures, which is a sister company of Sage, is going to talk about some alternative products that can be used, some alternative tools that are available to both attorneys and their clients at the time of settlement, where you are able to take advantage of market-based products, market-based rates. You don't have to be locked into the fixed annuity rates that the traditional settlement annuity offers. From there, Rich LaBelle and Nelson Perez from Family Network on Disability, who I have been working with and referring all of my trust business to for the last several years, are going to talk about various trust planning tools, different types of trusts, protection trusts, special needs trusts, and the various types of Medicaid related special needs trusts, and how to best protect clients using those tools. We're then going to transition over to Amanda Greenburg, who is with Archer, which is again another sister company of Sage. She is going to dig deep into, and I say dig deep, we have limited time today, but she will then dig deep into Medicare set-asides, and really what everybody should know and needs to know right now. As over the last several years, Medicare has been a constant moving target, and I think it's slowly zeroing in on what we need to know. So from there, Gale Murphy, who is also known to those of us who have worked with her for the last 20 years as Grandma Gale, is going to be talking about settlement documents, the language that needs to be in those settlement documents, and why it's all important. Oftentimes I get asked, what does this language mean? Why can't we just say this? And everything we do from the structured settlement side, from protecting the tax-free nature of the settlement payments that clients are going to be receiving, is all directed and dictated by IRS code. So Gale will dig into some of that for us, and then we'll wrap things up with questions. I think, Adriana, correct me if I'm wrong, everybody should email you directly their questions. That's how we're going to do it to keep it streamlined.
Right. So if everyone can just hold their questions until that part of the presentation, as you come up with them, you can use the chat to privately send them to me only, and that way I will have them, for Jay and the rest of his folks to be able to answer them. So just privately send them to me through the chat. The other thing that I just want to add is that also at the end, when we get to the wrap up and questions part, we'll be giving out the CLE credit code that Christy Fox, our executive director, has worked really hard to be able to get for all these webinars. So we will be giving that out towards the end of the presentation at that part. So yeah, just send me your questions and I'll get them over to Jay.
Thank you, Adriana. So that being said, most everybody who knows me knows that I have been in the structured settlement business since 2001, going into my 20th year now. I am very passionate about advocating for plaintiffs and protecting the hard work that you as attorneys have done to achieve the settlements that you're able to get for your clients. I made the decision not to use a direct case example today, because in order to encompass everything that we're going to be talking about, it would have to be a very large catastrophic case example. There is no minimum size to a case that myself or the other wonderful people you're going to meet today can get involved in. We are here to help you and help you guide your clients through the settlement process, whether it's protecting Medicare, protecting Medicaid, protecting clients from themselves, trying to figure out how to maximize growth, trying to figure out how to not have to pay taxes on any of the growth through the structured settlement annuity. There is no right case, there is no wrong case, but every case warrants a phone call if it's being settled, especially cases involving minors and incompetence. Those should be no-brainers. And then now, if you have somebody on Medicaid or Medicare, you should absolutely reach out to a professional to seek added guidance. So those are the things that we're going to be talking about today. Traditional structured settlement annuities are fixed, they're guaranteed, they provide creditor and predator protection to your clients. It is a great way to protect the money, but it's not the right way in every situation. And what Brian Smith is about to talk to you about can be very eye-opening. There are some thresholds that you have to meet dollar-wise for some of the products, but they're groundbreaking, and it's ways that we can think outside of the box for more sophisticated clients to realize real market gains on some of their settlement dollars while still deferring taxes. So that being said, I'm going to turn things over to Brian now and let him get started. Brian, just let me know as you need me to advance slides if I don't go quick enough. Here's and everybody's going to get a copy, I believe, emailed to them of the presentation if you'd like it. So you'll have everybody's bios and contact information as well.
Beautiful. Thank you for that introduction, and thank you for getting off the page. We don't want to scare everybody off from the start with my picture, Jay. So if your mustache didn't do it, mine would. So Jay, as Jay kind of opened up, what we have to offer is really very timely amid the market fluctuations you're seeing and the low interest rates on the traditional structured settlements. We've had this program for about 6.5 years now for the attorneys and about 4 years for the actual plaintiffs. What this is this market-based program that we have that Jay has the ability to work with you guys on. It's built on a traditional structured settlement chassis. And in that, you have to outline your payments up front, when they begin, how long they're going to go for. So it's very similar to a traditional structured settlement, but in the sense of instead of you having a fixed dollar amount that you know you're going to get every month or every quarter, every year, however you set those payments up, these are going to be fluctuating because it's based on the market. These are solely market-based investments, and what it is this allows you to use your financial advisor you have to manage these funds. If you don't have a financial advisor, we can recommend one, or even a third option on these type of programs is typical to a 401k where you can pick 6 model portfolios from a conservative to an aggressive standpoint. So it's what we call open architecture, which again allows you to use your own financial advisor, one that we can recommend for you, or those model portfolios. The key thing on a structured settlement is your payments have to be fixed and determinable. And so by that's under your section 130C in the IRS code. The IRS later came on with a couple of private letter rulings that really laid the foundation for our program here. As you can see on the slide up in front of you, is that one of them was set for variable annuities, and the other one was for fixed indexed with index linked riders and things like that. So that laid the foundation for the program that we've built now. So again, at the onset of these programs, all the obligations have to be set forth in the terms of your settlement agreement. And let me kind of this is a great time to kind of step back, and before we get to the settlement agreement, I kind of like to address, these market-based programs are not funded by a lot of the major carriers, like any carrier that has a very defined approving companies. They don't tend to fund these, but one of the key things you can do as an attorney to set yourself up for the best success and your plaintiff is in the mediation agreement. There's language that you can put in that gives you the rights, and I'll kind of read this off to you, but if you want this actual language, Jay will have this, or I can get it to you however you'd like. And it's the key thing you want to put in your mediation agreement is the plaintiff and their legal counsel will have the right to receive periodic payments using an annuity or a market-based structured settlement program. Such programs will be funded by defendant via check, wire transfer to the appropriate qualified or non-qualified assignment company in exchange for a fully executed settlement and release agreement, mutually agreed by the parties, and an assignment document. So that's kind of some key language to set into your mediation agreement early on. And that kind of lays the base for you to be able to, it doesn't oblige you to do this, but it at least lays it if it's something you want to do or the plaintiff, it fits the plaintiff, then it's a great opportunity. So let me kind of talk about the two programs, and we'll go ahead and stay on this slide for just a, well, that's fine right there. Yeah, let's, so let me talk about the two programs. So for the income and tax deferral for any contingency fee attorney for you guys, our program is called the Fee Structure Plus. And what it does is it just basically allows you to defer all of your income, like some other CAP programs, and you don't pay taxes or anything on this, and you're allowing your full settlement fee to be invested. Where right now, if you take a settlement and then put it with your financial advisor, you're having to pay those taxes right up front. With this market-based program, you're able to invest your full fee into the market to begin earning instantly. As you start receiving distributions, whether it's within a year or however long you set out, there's no time frame. You can defer it as long as you want. You don't receive a 1099 until you start taking distributions. Each year you get a distribution, you get a 1099 ordinary income sent to you that year for just the amount that you received. So it allows you to take full advantage of tax deferral investment growth in your program. And as Jay mentioned a little bit earlier, there is a $100,000 minimum investment amount for the Fee Structure Plus. Now for the plaintiff you're representing, it's either tax-free or tax-deferred payments for the plaintiff, depending on if this is a personal injury case or not. But the Settlements Plus it's more for the plaintiff that doesn't need the guaranteed payments. So many of the people you deal with do need that traditional fixed annuity, and that is the primary needs. And we're going to make sure that their guaranteed needs are met before we'll be able to offer this program to you, because again, there is potential for loss because you are investing in the market on these items. So again, these are for tax exempt 104 cases and non-104 cases. The difference between this program and your attorney fee program pretty much is this one has a $250,000 minimum. We hope we don't have return business from the Settlements Plus side of it. We have a much lower minimum for you guys because we hope we have a ton of return business from you guys, and that tends to be the case when you do this once. People really like these, and they tend to do many cases after that. So Jay's kind of got the flow, and I just kind of wanted to show you this isn't, even though it's a market base, the flow still looks like your traditional structured settlement annuity. You have a settlement agreement between your injured parties and the defendant. They're both going to agree on, cash and a promise of future periodic payments. The defendant then has to agree to fund the payments with the assignment company, which is a Structured Assignments LLC, and they're going to do that through a non-qualified assignment. And then the assignment company then transfers the fund to a third-party custodian who is kind of the traffic cop in this whole situation. And they're the ones that are going to handle the distribution of the funds. They're the ones that are going to be handling the tax reporting, sending out the 1099, and they work closely with the financial advisor. So from there, the third-party custodian, they open up an account on the financial advisor's platform, whether it be a Fidelity, a Schwab, or any type of account like that. So they open up the account, the money sits on that platform and is managed by that financial advisor, whether it be yours, the one we recommend, or that model portfolio ones we discussed. So the money is sitting there, it's being managed based off of a discussion that you're having or the plaintiff is having with that financial advisor. And that's kind of one of the key steps. At the very onset of this, you're going to lay out an investment policy statement. How are these funds going to be managed over the time that it's sitting in this contract? So whether that be, from conservative to aggressive, whether you're doing, a mix of stocks and bonds, equities, whatever, that's all laid out at the onset. And again, the reason this is all set at the onset is it's keeping that constructive receipt issue away from you. So you're not having the immediate taxable case hit you. So this allows it to be deferred. So the investment advisor then stays in constant contact with the third-party custodian. And as your payments come due, the custodian and the financial advisor coordinate, and they will work with saying, okay, here's what's coming up. We need a distribution of X dollar amounts. And then the financial advisor liquidates that amount, sends it back to the custodian, who then sends it on to you or the plaintiff. So how do we get to that dollar amount? How do we know what the payments are? Let's go to that next page. So what we do on your traditional structured settlement, you know when your payments are going to start, you know how long they're going to go for, and you know the exact dollar amount. But on a market base, you can't do that. So how do we get that fixed and determinable that the IRS calls for? Well, what we do is we base it on a unit calculation. So let's say you've got a $100,000 fee that you want to structure. What we do at the onset is we will say, okay, we're going to take a unit value of $10 and we're going to divide it by that $100,000. That's going to give you 10,000 units. And let's say you're going to want annual payments over the next 10 years. So what that basically means is we're going to distribute 1,000 units each year for you. So that third-party custodian, about 5 days before that first annual payment's due, they're reaching out to your financial advisor and they're saying, okay, I need a unit or a account value right now. They'll give them an account value. They then will calculate what your payment will be based on those units, and they'll distribute that to you. And that's done each year. And then that year, you'll receive a 1099 ordinary income for that amount, for that 1,000 units. So that's where we come up with the fixed and determinable. So you'll have the total dollar amount invested. You'll have when your payments are starting, how long your payments are going for. And then instead of a dollar amount that's set for each payment, you're going to have a set unit amount that's set for each payment. Again, this is based off of the IRS. This has been in play for about 5.5, 6 years. We have lots of tax opinion, private letter rulings that back this up. If you do have any questions about these, myself or Jay have all the documentation for the program. It's been fully vetted, audited many, many times, and never challenged. So we're very comfortable with it. And again, it's built on the same structured settlement chassis that's been in our industry for years. So, you know, this non-qualified assignment that we use, the program we use, has been utilized by major life insurance companies as Allstate, Liberty, Prudential, and many others. And again, it's been tried and true and tested. And we have private letter rulings. We have tax opinion letters from many prominent tax lawyers out there. That's kind of a quick 30,000-foot overview on this. I know we're really pressed for time, but if we have any other questions, myself or Jay, be happy to answer any questions you have. Or if you want to have a more in-depth conversation, please contact Jay and he can schedule a call with myself and Jay and you, and we'd be happy to go over more of this. So with that, Jay, I'm going to kick it back over to you.
Well, I thank you, Brian. Great job, and I appreciate all the information that you were able to share. For those of you who may have joined in late, we are giving away a basket today. This screen will pop up one or two more times throughout the presentation, but please email Melissa if you are interested in entering to win the raffle. So now we're going to change gears a little bit. We're going to go over to Rich LaBelle and Nelson Perez with Family Network on Disability, and they are going to dive deep into deep as they can in 10 to 15 minutes in trust planning and public benefit preservation. So Rich and Nelson, the stage is now yours.
Great. Thank you very much, Jay. We greatly appreciate it. And if you could just go to the slide that says types of special needs trusts, that would be, so yep, that should be fine. Great. Actually, I'm sorry, one back, the special, there we go. Okay, so let me just say that FND Trust Services, a family network on disabilities, we are up and running full speed during this crisis. A lot of our staff works remotely all the time in any event, but our central office staff is working very smoothly and very happy that we haven't had any speed bumps along the way. So whatever you may need, whether it's getting documents signed, notarized, witnessed, whatever, we can help arrange that as we go through the process. Also just wanted to mention that in addition to the special needs trust services and other trust management services that we offer through Family Network, we do have several federal grants to reach out to families of children, students, and young people with disabilities, whether they're in the educational system or navigating the medical system, and especially now with mental health issues. So all of those services are absolutely 100% free. And if we can help you, if we can help your clients, if we can help your family or friends, please reach out to us, and we're very happy to do that. There's, as you know, there's lots of stuff going on with schools and whether they're going to be open and closed. How do we go about educating kids in the meantime? And then again, the mental health impact. So please, if we can help, we're very happy to do that. So let's turn now to special needs trust or supplemental trusts. And special needs trusts are called special or supplemental, not because the person with disabilities for whom these are established has special needs or they themselves are special, but this is because the money that's in the trust is designed to pay for special expenses and supplemental expenses above and beyond whatever their public or government benefits may pay for. So that's where the term special needs trust comes from. And these are appropriate to use when there is going to be a continuing disability for the plaintiff post-settlement or post-verdict. So going forward, if you know that the plaintiff is going to have those types of issues, then it's important to set up a special needs trust. Why is it so important? Because what you want to be able to do is to preserve access to public benefit programs like Medicaid, like SSI. Medicaid is really the big one, but it's often crucial for trust beneficiaries because we've been doing this for many years now, and we handle, as Jay said, all size of trust. So we have no minimums. You know, 0 is our minimum. So if you know, whatever the size of the award is, we can help you with that. But even with the larger trust that we're fortunate to serve as trustee for, you know, multi-million-dollar awards, we find that even then they are often challenged in terms of their medical and living expenses, and that those often exceed in the real world with medical inflation 5-10 years down the road, whatever it may be. It often exceeds what they recover. So being able to preserve their eligibility to receive Medicaid and other benefit programs can help preserve and prolong the life of the trust funds for as long as possible. And that's really, really what we're going for here. Next slide, please. Okay, so I'm going to talk briefly about a couple of different types of trusts, and then I'm going to turn it over to Nelson. Generally, what we talk about, the main difference in how trusts are referred to depends on where the money comes from. So if we're talking about a third-party trust, that means that the money is coming from a third party other than the plaintiff or the beneficiary. And so if the money touches the hands of the plaintiff or the beneficiary legally at any point, and they want to qualify for Medicaid, then it has to go into something called a Medicaid payback trust. And we'll touch on that a little bit as we go through here. And it's called a payback trust because Medicaid has a lien on those assets. And if the beneficiary passes away and there's any money left in the Medicaid payback trust, then before any other expenses can be paid in general terms, the Medicaid has to be paid back for all the medical expenses they've paid on behalf of the beneficiary. So as you might imagine, those liens can be quite significant at times. So in terms of the types of the trusts, third-party SNT, that can be established in a separate document. It can be established in a will. My preference is that it be established in a separate document because you don't know when the law is going to change. And so right now in Florida, third-party special needs trusts are not considered payback trusts. And that means, Medicaid does not have a lien on the assets in those kinds of trusts. I hasten to add that that may change in the future, and there are constant revisions to these statutes and the requirements. But right now, the best thing about the third-party trusts is if you can set them up, then it's not a payback trust. Medicaid does not have that lien. Self-settled trusts, these are specifically authorized in federal statute. They're often referred to as D4A trusts because that's the shorthand for the federal statute that you see the site for there. These are established with the beneficiary's own funds. So when the money touches the hands of the beneficiary of the plaintiff, it can go into one of these types of trusts. Usually, these are used for larger awards because there's more flexibility than other types, which Nelson will talk about in a second. A real important caveat is that these can only be established for people who are under 65. So they need to be set up and they need to be funded completely before their 61st or 65th birthday, sorry. And this is a Medicaid payback trust. So as we discussed, on the beneficiary's passing, if there's any money remaining, then money has to be paid back to Medicaid. If there's funds after the Medicaid lien has been satisfied, then those can go to whomever they choose to designate, family members or other types of subsequent remainder beneficiaries. Next slide, please. Okay, I'm going to turn this over to Nelson, and he's going to handle pool trusts and settlement protection trusts. Nelson?
All right, well, thank you very much. Nice to see everyone. Thank you, Jay, for the introduction again. I'm sorry I didn't grow a mustache, but I've grown a beard for the first time in my adult life through the quarantine, so I'm pretty pumped about that. And apparently, if I'm too loud, my home office coworkers have told me I'm shouting on these Zoom calls, so I apologize for my volume. Anyway, as Rich said, a pool trust is just another kind of special needs trust. In the statute, it's called D4C. We have the pool trust joinder document. It's already been established. It's been approved by the Social Security Administration. The document itself is fillable. We can send it to you. You can fill in the information and your client can establish the pool trust. How it works for investment purposes, like it says in the slide, think of it as a 401k. All the investments are pooled together as one fund, but then each individual client will get their own statement. They'll get an accounting of their activity. They'll know what's going on in their fund only at any given time. And that's true for the beneficiary, the guardian, whomever they designate to get that information. Most of the time, the pool trust is used for more modest rewards, I usually say anything under, 50, 100,000 should probably go into a pool trust. The cost is just a one-time setup fee. You don't have to have the trust drafted by an external attorney, so it saves money there. The administration is a little bit easier. It works better for those types of clients. And then, the distribution model we have is very, very efficient with the pool trust. So we approve distributions usually within 24 hours, from time of approval to time the beneficiary gets their check or gets funds on their card. It's usually about, 4 to 5 business days. So, but again, there is no minimum there. So if you have a client who's, going to get any amount of money over the Medicaid or Social Security threshold, and they need to, put that money somewhere, you can set up a pool trust. We also have the family pooled fund. That's a third party pool trust. So that would be, if you're helping a client do some planning, if they have, gotten an award themselves and they have that money, but then they have a disabled, family member or a child with a disability that they want to leave those funds to, they can establish the third party pool trust. And then those funds would be directed into that trust, upon their passing as they designate. The other caveat that Rich spoke about earlier, and this is a very important one, if you have a beneficiary that's over the age of 65 and they are on public benefits, they have to establish a pool trust. That is the only option they have. There is no other option. We've looked into this. We've talked to multiple, people of ways to change this. It just, if they're over 65, they have to have a pool trust. We're very sensitive to, estate planning. And so we have an addendum that goes along with that pool trust if your client so wants. I know a lot of times with the older clients, if they're putting significant amount of money in the pool trust, they're concerned with the nonprofit retaining those funds. So we try to help them navigate that as best we can and keep those costs down. And then just the other important thing to note, pool trusts are also Medicaid payback trusts. So there is a payback to Medicaid upon the passing of the beneficiary. And Jay, you can go to the next slide. Next slide.
For some, oh, there we go. Sorry, I wasn't
Rich,
working.
did you want to touch on this?
Yeah, I think we pretty much covered this, so we can go on.
Okay. So I'll go over settlement protection trusts. So, I know I've worked with a lot of you on these, but they're generally speaking, they're used when there's no continuing physical or mental disability. There's no benefits to preserve, but we want to protect the award your client has received. So it provides creditor and predator protection. It's flexible from a distribution standpoint, and we can set them up multiple ways. You can set them up for a minor child, and that protects the funds the same way a guardianship would, in that you have a corporate trustee and a fiduciary watching over those funds. They're invested conservatively according to the Florida Prudent Investor Act, and we manage them and we take care of them, and the parent does not have direct access to the money. We've gotten that question a lot from the courts, and we're watching over those funds and we're taking care of them for that child. For an adult, it's a little different. Again, they want the creditor-predator protection. The trusts are irrevocable. They can designate beneficiaries in this trust, but it's another layer of protection for them. So they're just not getting money outright, and then, for lack of a better term, may go out and blow the money. It helps us do some estate planning with them, some financial planning with them, and it usually helps the money stretch, much longer than you would just handing them a check. These aren't in federal statute. These vary from county to county. So we have gotten them approved in most every county in Florida at this point, both through the probate and the civil courts. So it works either way. We're always happy to, this is still, we've been doing these a few years now, but it's still a relatively new concept. So we're always happy to be either on the phone or in person with you at a hearing if you need it to be explained to a judge or to a court. Right now, we're participating in Zoom hearings. We're participating in telephonic hearings. So, anything like that, we are more than happy to do. And actually, that brings me to another point too, which is when you send over your orders, we usually get certified copies of them. Right now, we don't need that. Electronic will suffice. We have the online notary services that Rich talked on. So all of our documents we can get to you, they can be e-signed with online notary. The paper never has to pass through the client's hands. Again, the best thing about these for minors is that it reduces cost. So it's more efficient because we approve the distributions, same as the pool trust and the SNTs. The distributions are approved within 24, 48 hours, and the money gets to the client or whomever needs it, within 4 to 5 business days. But they come to us, it doesn't cost them anything to do that. as with a guardianship, a minor guardianship, you'd have to go to court, you have to get it approved, you spend the money to open the guardianship, the expense to hire the guardianship attorney, you know, you go through all that, and then any distribution that's needed, you then have to go back to the court, and you can spend, you know, several thousands of dollars doing that over the years. So it keeps costs down a lot, and the model's more efficient. And then we will budget with the client. So we will go over, if it's a minor client, you know, what are the needs now? What is our goal when they become an adult? In the document we use, they have several windows where they can take their money. So 18, 23, 28, and 32. So they have different windows when they can withdraw. They don't necessarily have to do it when they turn 18, though they do have the legal right to do so. But it allows, you know, more flexibility if they become an adult. The other thing we've done with these is we set them up for international clients. So clients who may necessarily be in the United States, but the situs is here, the trust is set up here, but they're in different countries. So we've been able to set up different transfers to clients in Mexico, Brazil, you know, other Spanish-speaking countries, the Dominican, things like that. So we can help you, you know, navigate those kind of complex situations where you're like, I don't know how to get this client money on a monthly basis, quarterly basis, what have you. And then Jay, next slide. So, you know, as you guys can see, you know, we have all of these different options at your disposal. Your first party special needs trust, third party special needs trust, the pool trust, the family pool trust, settlement protection trust. There's no one size fits all for any client, but we try to be as efficient and as flexible as we can. And we try to do it the best way we can for your client. So there's nothing you can't call us about. We're happy to help. We will actually tell you if you don't think you need a trust. We're not, you know, like Jay said, we're just here to help you, to provide added service to you. So if you have any questions after this, you know, please let Rich or I know. I know we kind of just went over this bare bones, but if you need anything, you just let us know. And thank you, Jay.
Thank you, Nelson, and thank you, Rich. Great job, great information, as always. Again, if you've joined us late, please email Melissa if you're interested in winning the basket. For 2 more seconds so that everybody can get the email address. Okay, now is the fun stuff. We're going to get into Medicare compliance with Amanda Greenburg. Amanda's with Archer. Some of you who've been working with me in the past may be familiar with Providio. Archer consumed, I guess is the best way, or absorbed Providio when Millennium and the Settlement Alliance merged at the beginning of 2019. So Amanda is wonderful. She's the Vice President of Single Event Sales at Archer, and she is going to share some great information with you this morning. Amanda, the floor is yours.
Amanda, you might have to unmute.
Do we have her? It'll look really silly if I have to do your role here, Amanda.
It says she's on. She's listed as a participant.
Hang on.
Looks like she's connecting to the audio now.
Not exciting enough. The bill also created 6 new county court seats for circuit traffic cases. Looking through general courts, there was a bill that passed relating to recreation.
Again, just a reminder to everyone, if you can please mute your microphone. If you're not on mute, we can hear your private conversations. So just letting you know to mute your microphone.
Okay, well, maybe let's, I just sent Amanda a text. What I'm going to do is hopefully Gale Murphy is ready to go. I'm going to fast forward to see all this information that Amanda's going to go over. I'm going to jump ahead to Gale and let Gale jump in and talk about the settlement documents and language that's required when you're doing a structured settlement annuity to be in all of the release documents and everything else. So that being said, here's Gale. Do you want to jump in?
Sure. Can you hear me?
I can hear you. Yes.
All right, great. I will try to move through this very quickly as I know Amanda has a lot to cover, and once her audio is up and running, she'll be anxious to get through her section. So we just felt that it was important for us to briefly talk about the settlement documents and the required language that the IRS wants in those documents to protect the tax-free status of your client's payments. Our number one goal is to make this as easy as possible for you and not to slow down the overall settlement process. Now more than ever, it's extremely important that we handle everything efficiently and as quickly as possible as you guys are trying to navigate these uncharted waters with the COVID crisis going on. Thankfully, we've been able to adapt and modify some of our processes to accommodate this current environment. One of the first changes that we looked for with regard to our life company's partners is to ask them to accept electronic signatures. So I know that they just talked about that on the trust documents. That is also available on your standard structured settlement documents. So all of the life company partners are now accepting those electronic signatures. This way we can still finalize the settlement and you don't have to have those face-to-face meetings with the clients. Additionally, and this isn't really a change in our process, but just something that I felt was important to mention is that we do not require original signatures on any of the documents. We will accept a copy, scanned copy, fax copy. We do not need the originals. So now let's move on to what is required. And some of the basic information which you're used to providing to us is the name, the gender, the date of birth, the basic information about the client. We also need the exact cost of the annuity or the net to the client. So if you have your final settlement statement already prepared, if you'll send that over at the time that you want us to start working on the documents, that will help us get everything accurate the first time around. And I know that a lot of times there's liens and expenses that aren't captured yet, so you might not have that final settlement statement done, but if you can just get us the net to the client, that's super helpful. We'll also need the name of the insurance carrier or the entity cutting the check. It's important for us to have full cooperation from the defense at the beginning of the process. We don't want them to, come in later and say, well, we'll cut a check, but we're not going to sign the document. So if we can have those conversations with them early on in the process, it will make everything run smoothly. So after we have all of this information and a structured settlement design has been approved by the client, we will then send a confirmation of settlement email, which will include all of the required documents. It will include the check request, the information request form, the language for the release, as well as the qualified assignment document. And if there is a minor or an incompetent adult, we'll also require the language that needs to be put in the petition or the order. Next slide, Jay. So let's quickly just review what these documents are and why they're required. The annuity check request is simply the document that is provided to the defense with the instructions on how to make the check payable. This document is typically sent, go back, Jay. This document is typically sent over with your firm's W-9 for the portion that is going to cash. And it has the instructions for them to make the check payable to the assignment company with that assignment company's tax ID number, and then Sage's mailing address so we can process the check. The information request form is the information we need to complete the application. It's going to have a lot of that information that I just said we needed. the full name, date of birth, address information, but it will also allow the client to designate a beneficiary. And if they want to have their funds direct deposited into their bank account, we'll capture that information on the information request form. Next. Now let's review the language that needs to go into the release. This is the critical language that the IRS is going to look for if they ever wanted to review a structured settlement or a settlement document. The IRS code is very specific regarding the requirements of the language. There are typically 6 paragraphs required, and each one deals with a separate part of the IRS code. The first section is the payment section, or the consideration language. The consideration language should always be listed as an immediate cash payment and the future periodic payments. So the portion being paid to the law firm for fees, expenses, and any upfront amount going to the plaintiff would be listed in section 2.1. And then the periodic payments, the portion that will be placed into the structured settlement, is listed in 2.2. And this specifically lays out the amount of the payment, when they're going to be made, and any specific conditions around that payment. Next, please. All right, now, is there a section regarding the payee's or plaintiff's rights to the payments or lack thereof? The IRS code states that the payee cannot accelerate, defer, increase, or decrease the payments once they're established. Basically, they have no rights to make any changes once the settlement is in place. This meets the fixed and determinable aspect of the IRS code, and it needs to be done at the time of settlement. Next. Since the payee doesn't have a right to make any changes to the payments, including a beneficiary designation, if it's not outlined in the documents, it's important to add in this section regarding the beneficiary. This gives them the authority to designate a beneficiary or make a change if some time in the future their beneficiary designation changes. And then the next section, which is kind of the meat of the settlement document, the settlement agreement paragraphs, is that the plaintiff must acknowledge and consent to the assignment process. Brian talked a little bit about the assignment process on the market-based products. It is very much the same if you're just using a traditional annuity product. The plaintiff must acknowledge and agree to the assignment, and it also is providing the defense, which is important to the defendant and the defense side, a complete release of those future periodic payments once the assignment process is completed. So you will see the consent to qualified assignment paragraphs within the required language that we send over to you. And then the next to last paragraph, is the right to purchase an annuity. So the defendant will fund those future periodic payments by purchasing an annuity policy from one of the life insurance companies that work within our space. In this case, we've utilized Pacific Life Insurance Company. And this is just authorizing the assignee or the assignment company to purchase that annuity for those future periodic payments. The last paragraph, which I don't have a slide on, is the discharge of obligation paragraph, which basically states that upon the mailing of the check or the EFT, processing the EFT payment, the obligation to make those payments is fulfilled. Now we'll move on to the assignment documents, and this is the actual document. We've established the periodic payments in the settlement agreement. We've acknowledged that the plaintiff understands that a transfer of obligation will be made, And then the assignment document is the actual document that transfers that obligation. We typically will use a qualified assignment and release, which is a 3-party agreement. And that 3-party agreement includes the plaintiff, the defendant, and the assignment company accepting the obligation. This we feel like is just another layer of protection by having the plaintiff sign off on this agreement as well, that they understand the process and that they are ultimately to look to the assignment company or the assignee for their future periodic payments. There's also just a qualified assignment, which is a 2-party agreement. And that is typically just between the defendant and the assignment company. And there's also a qualified assignment release and pledge agreement, which provides that payee a secured creditor status. So the final steps, in summary, we try to make this as easy as possible for you by providing everything you need in one confirmation email. All of the documentation will be included in that. We will then be happy to review any draft documents to ensure that the required language is accurate. Once we have the signed documents back, we're going to do another review just to make sure that nothing got changed between the draft and the final. And then we ultimately will send that to the life company for the annuity contract to be issued, which is kind of the final step. The annuity contract is issued and the fully executed assignment document is provided. I know I ran through all of this quickly because I wanted to give Amanda plenty of time to discuss her sections. But as the structured settlement expert, Jay is here and willing to give you further information on any of these requirements, and obviously will help you throughout the entire process. So Jay, you can have it back.
Thank you, Gail. Great job. I am going to get back to the beginning for Amanda. She had some technical difficulties earlier, but I believe we now have her back on board with us and she's ready to go. Amanda? Well, maybe we don't. We have you, Amanda? Unfortunately, Amanda is suffering from technical difficulties today. Let me see. It's not letting her talk for some reason. Amanda, can you try to dial in to the call from your cell phone and do it that way rather than through the app? She's trying to do that now. I apologize, everybody. When you try to do this with multiple people, and for me, trying to do this for the first time, sometimes there's a glitch. So, while Amanda's dialing in, Adriana, do you want to put out a question or two to get us going there?
Yes, absolutely. We have a few questions. Let me just pull them up. The first question we have is, does Medicare have a lien on third-party trust, and does this depend on whether there are minor beneficiaries?
Richard Nelson, you want to take that?
Sure. As I understood it, the question was, does Medicare have a lien? Is that correct?
On the third-party trust,
Yeah.
does this depend on whether there are minor beneficiaries?
No, there is not a lien for Medicare, and it doesn't depend on minors or not.
Amanda, do we have you now?
I hope so. Can you hear me?
We can hear you. Thank you.
Oh my gosh, thank God. I'm so sorry. I'm not the most technologically savvy person, but I do know my stuff about Medicare, so we'll get started on that. First of all, my name's Amanda. My name is Amanda, and I'm with Archer. We are a lien and Medicare set-aside company. I'm going to talk to you guys about Medicare today, but I did want to touch base really quickly about liens and just provide a quick update on what we're seeing on lien holders. because, we're tracking, we have, thousands of liens in-house, so we're tracking the lien holders, and I want to give you some assurance that they're still working. Most of them have moved to remote. Medicare is still working. I mean, believe it or not, even New York Medicaid is still working. So we're still seeing responses from the lien holders because they don't want your settlements to get jammed up because you can't get the liens resolved. If anybody wants any cases or information on that, please just give me a call. We're tracking all of it to make sure that people can still get those things taken care of. Medicare set-asides. So Medicare was enacted in 1966, and it's government-sponsored medical coverage for people who meet eligibility requirements. That's key because it's an earned benefit. It's not something that's just given, or it's not a qualifying one, but like Medicaid, where you have to have it's needs-based. The way that you become eligible for Medicare is by age, if you're 65 or older, or through SSDI, which is where we see this in a lot of our more catastrophic cases, because you have people who, maybe a 40-year-old gets in a car accident and he becomes a quadriplegic. He can no longer work at the same job that he was doing before. We'll see them, he will lose his company insurance and will apply for SSDI, which is disability insurance, and try to get that so he has some additional income. When they do that, when they are approved for SSDI, they do go on to Medicare after 2 years of the date of the approval. And so that is where we see these kind of pop up, because you see these young people and you think, how can they qualify for Medicare? I thought that's for the older population, but this is how they become eligible, and believe it or not, they can even qualify. Like the credits is on a sliding scale. So I've seen people as young as like 19 qualify for Medicare. So it's very interesting on that. So, you have to kind of keep, check to make sure that they haven't applied for SSDI. And then Lou Gehrig's disease and permanent kidney failure also puts you on to Medicare as well. Next slide, please. Medicare Secondary Payer Act is a 1980 statute, because I know we're short on time. Basically, this slide and the next slide say that for Medicare, you have to A, consider Medicare's future interest, and B, document your files. And that's where we see the authority for Medicare set-asides come about, and it's also the authority for repayment. Next slide. A Medicare set-aside is a trust-like agreement to hold settlement proceeds for future injury-related expenses. So basically what Medicare doesn't want plaintiffs to do is, essentially, they see it as double dipping. So if a plaintiff gets $1 million awarded for future medical expenses, and then they keep the money, Medicare's position is, well, why do they get to keep the money and we still have to pay the expenses? So the way that they've handled that is through a Medicare set-aside. There is no requirement to do a Medicare set-aside in a liability case, and believe it or not, you don't even have to necessarily do one in a workers' comp case. It's just become this industry norm, and there's so much guidance on it that everybody does them in workers' comp, and then they have now started to look at them for liability cases. Next slide. I'm going to breeze through this really quick. So this is what happened is in 1980, the Medicare Secondary Payer Act came about. In 1995, the first one was done in a workers' comp case, and from 2003 to 2011, CMS published about 70-ish pages on how to do a workers' comp MSA. They provided guidance like, if I have a group health care plan, is that primary to Medicare? So they established payer priority, they established how to do it, and they provided some guidance on how to do that in workers' comp. Unfortunately, they did not mention what liability you should do in a liability case. So we're kind of left to kind of figure it out on our own. Next slide. In 2007, the Section 111 reporting obligation came about. That requires the defense to report on injury-related, what they're settling for on injury-related codes. And then in 2011, CMS Regional Coordinator Sally Kelly Selcup published a memo saying that you do have to consider Medicare's future interest in a liability case, but didn't say how. CMS was pretty silent on it until about 2016 in June, when they said, okay, we're going to do a bunch of town halls, we're going to do a bunch of things, and we're finally going to give you some guidance on this so that you don't have to worry about it anymore. And then we start getting to what I think is a really interesting point. Next slide. Which is, this is what the process looks like, workers' comp versus LMSA, and this is how it's different. And this is what it looked like in 2016. The first step is, in both cases, is that an MSA certified nurse allocator generates a report, and that report outlines all of the future injury-related expenses. So if, for example, going back to the quadriplegic case, they would cover durable medical equipment, meaning the beds or the wheelchair, or they would provide some kind of doctor's visits. They do not cover home health care. They do not cover facility care. So while your life care plan may be huge, that is not indicative of whether that your Medicare set aside will be huge, because most of the stuff in your life care plan is not covered by Medicare. The second step is in the workers' comp process is that you submit to CMS. In the LMSA process, there's a bunch of different CMS regional offices, and if you submit, you get a variety of responses. The one that I thought was the most interesting was an auto-generated letter that says, due to resource constraints, we are unable to process this at this time. However, this letter does not constitute a safe harbor from the Medicare Secondary Payer Act. Well, that's really interesting to me, because safe harbor implies duty, which means that they think they're already covered under the Medicare Secondary Payer Act. So while they haven't issued guidance, I think they already think the authority kind of exists. The third step is that CMS would send it to a contracted nurse for the workers' comp process. So CMS has outsourced this. They've hired a bunch of third-party nurses, and they review them, and they basically give but there's no ability to do this in LMSAs. And so the contracted nurse will give a thumbs up and thumbs down. They review it, they see if they came out with the same price. Sometimes they have a little bit of a difference variation. Maybe they're allocating for 3 PT visits versus 4. But because we have to use the same fee schedule and Red Book for the prescription pricing, there's not a lot of deviation from what a nurse allocator, the attorney nurse allocator, will come up with from CMS. You might see a small variation, and sometimes I even see them go down just a little bit, but it's pretty much spot on. CMS, on the workers' comp side, they send it back to the nurse or the attorney, and the claimant pays for it on the workers' comp out of the fund until the fund is exhausted, and then Medicare resumes as a primary payer. In the workers' in liability, all of this is unknown, because you can't get the approval or the documentation from CMS. And a quick practice pointer, because we're seeing them pop up in a lot of cases now. If CMS wants you, if the defense wants you to put in there that you need to submit to CMS on a liability case, do not allow it. You will end up in a very bad waiting position, because it takes CMS about 9 months to respond to even provide a non-response. So you don't want to get caught up, because that's going to hold up your funding. Next slide. So this is where stuff starts to change a little bit at the end of 2016. Remember, we have these contracted nurses that we just talked about in the workers' comp side, but there's no available nurses to review liability. Well, this is where stuff changes, and this is where people started to take notice in late 2016, which is CMS issued a request for proposal asking for nursing contract bids for workers' comp and LMSA review. They asked for $12,800 for workers' comp and $19,200 for LMSA. So they were establishing the scope of labor. Obviously, I highlighted the date because obviously CMS blew their own deadline and their own thing, but these are just things to consider so you can get a global picture and determine how you want to handle your cases. Next slide. 3 months later, they issued Change Request 9893, and I think this is kind of where it was a game changer. It's a directive to billing operators, both medical offices and durable medical equipment operators, to deny payment when a liability Medicare set-aside should be in place. This went into effect in October 2017 and still is in effect. So technically, the billing operator is, you know, the person, it sounds so technical, but it's really just the person, you know, it could be, you know, the person in accounting at your doctor's office, or it could be, you know, a large accounting department at a hospital. We don't see them deny requests that often, but when they do, it's real. I'm dealing with one right now. Sad case, you know, not enough money, and they're denying her, a young woman who's a quadriplegic, treatment from her ortho, which is just insane. Next slide. So this is where the timeline, and I'm going to breeze through this as fast as we can because I know we're running over a little bit. But so we have the request, December 2016, we have the request for proposal of labor. February, we have this 9893. September 2017, the request for proposal of labor, they've got a new contractor, immediately goes into dispute. Just a side note, there's a rumor that that contract went from $6 million a year to $60 million a year. So there's some perception that, of course, there's going to be an increased scope of labor if they have so much, if they're going to pay so much more. I mean, they're going to want some return on their investment. That dispute was resolved in December. The new contractor started March 2018. In April 2018, NAMSAP, the National Association of Medicare Set-Aside Professionals, sat down with CMS and they said, it's okay, don't worry about the new contractor, it's going to be about 18 months. They really held firm on that position. They reiterated it at the NAMSAP conference in September 2019. Everybody thought it was going to be October. Not true. There was nothing. Then they pushed it, and forgive me, the slide is incorrect. They pushed it to February 2020, and that was a month ago. We're in the middle of a COVID crisis. I don't picture CMS putting this on the front lines of something that they need to handle right now, but we're also going to see a lot of very sick people, unfortunately, and we already have. And, you know, Medicare is going to look for ways to cut costs as well. So we don't know what the climate's going to look like. And that's just kind of where we're at. Next slide. So this is the same slide from 2016, and this is where we're at now. I've highlighted the differences. You know, they didn't have a contracted nurse to review. This may have changed. No ability to review for now. They may have hired the labor. And payment can be denied under Change Request 9893 for failure to have an LMSA established. And so this is where the changes are, and this is why these past couple of years have been relevant. It's why we're seeing them. I see them pop up a lot of times with the defense. The defense perceives it as exposure, and so they're making a condition precedent to settlement. And so while, you know, and it's very confusing for me as a former plaintiff's lawyer who obviously wants to get all the nits to my client, and I, you know, and that's actually where I got into Medicare set-asides, because I don't see a clear and concise rule, and I don't see clear and concise guidance. But you know, unfortunately, it does look like they're setting up hurdles and challenges. Next slide. This, we just touched on this. They cannot review them. They do not, you know, it says we're going to review them on a case-by-case basis. That's scary and vague and ambiguous. Next slide. I get this question all the time. How does CMS know when an LMSA should be in place? It's the CPT codes, the ICD-10 codes. When you report an injury and say broken right arm, that's given a 5-digit code. When the defense reports under Section 111, what they settled for on the injuries, that's a 5-digit code. It becomes flagged as an injury code for billing purposes, which is why Change Request 9893 has so much relevance, because it all has to do with billing. Next slide. This is a flow chart. I referenced those 70-ish pages of CMS memos. And instead of making you all read them, because I did, and nobody should have to do that, we basically put it into a flow chart. It's a how-to guide on how, if you need to consider Medicare's future interest. It has thresholds. I'm happy to email Jay, and I'm happy to share this flow chart with everybody on this call. You know, it basically just gives you a cheat sheet. Is the client currently on Medicare? Is the settlement for more than $25,000? Can the treating physician certify that no future treatment is recommended? No set aside if he can, no set aside if he should. And so we're happy to, I won't go through all of this with you, but I'm happy to share it. Next slide. There is some authority to reduce them. I'm happy to, we can discuss that at another time, but just know that, you know, there is case law to reduce. Next. There are some options on way to avoid them. If we can, we try to do an opinion letter so you can document your file. And next slide. You can professionally administer. We have a lot of companies that do that. The next slide is funding, which you should talk to Jay about. Jay's one of the best settlement structure people I know. This actually makes Medicare flip-flop back and forth between being the primary payer and the Medicare and the MSA fund. So it should be used, honestly, in almost every case. It should be used pretty much in every case. And that pretty much wraps up Medicare set-asides. The key is put yourself in a defensible position. You don't have to do a Medicare set-aside on every case, but you do need to show why you didn't do one or what your thought process was to put yourself in a defensible position if your claimant is denied treatment. Thank you so much.
Thank you, Amanda, and thank you to Brian, to Rich, to Nelson. Thank you to everybody, to Gale. You all did wonderful. I apologize that we went over. We are trying to touch a lot of bases for everybody and cover a lot of information today. Adriana, do we have a little time to take a couple more questions? How would you like to handle that?
So we would love to be able to have everyone's questions answered. Unfortunately, the Zoom account we need for another CLE, that one that Jeff has starting right now. So I have the questions written down. I will send them over to you, Jay, and then we can connect everyone. But I encourage everyone to please reach out to Jay. I put his information on the chat. He will then, you know, forward your questions to the right people from the rest of the team. Again, thank you, Jay, so much for putting this webinar together for us at the last minute, for being our champion of justice, for everything you do for the Palm Beach County Justice Association family. Nelson, Rich, Brian, Gale, Amanda, thank you all so much for all of your help with all of our cases. We will be back next Friday at 11 for another webinar. Please join us, and please email me or Jay or anybody else if you've got their contact information with any of their questions. We'll make sure that they get answered. And please connect with them when you're going to settle these cases. You know, obviously we heard about tax deferral benefits. We heard about, you know, maximizing the settlement, protecting clients' benefits. All are so important. So thank you all so very much.
Thank you, everybody. This last slide that I have up here does show the Florida Bar CLE course reference number, which is 2002316 November. Please make note of that, Adriana. I think if we could circulate this slide, it may help everybody also who participated today, so that they do have everybody's contact information readily available.
We will, and we'll pass along with the gift basket when you announce the winner.
Right. We will announce the winner. Actually, the winner just popped up, and it looks like the winner is Jeffrey Mansell. Jeffrey V. Mansell. So, Jeffrey, you want to send Melissa another email and give her your address? We will make arrangements to get this delivered to you. Thank you all very much. Thank you to everybody. Have a great weekend.
So much.
COVID free.